yesterday I told you how the harvest is so huge, but the harvesters are very few. So in that process, you'll always find that people will not offer services in terms of very high quality and standards, because either the harvest is too huge for them, or they don't prioritize the harvesting because of the value that they attach to the harvest. Okay? But if we have an M&E tool that will assist us to monitor each and every stage of whatever activities that you want to do, then we are set for failures. So the first thing that you need to do is planning. And in the process of planning, you need to know what are your inputs, and what are the activities that you want to undertake. And that is now you start the how process, okay? And then you will ask, we have the activity, we have the input, and then how are we going to actualize, okay? What outcome do we want to actualize from the activity and then from the input that we have? And inputs could be people like resources, it could be money, it could be equipment that you need to facilitate the activities which you have identified. Then of course, you do the implementation in the field, and then after that, you want to see how you fared on with the planned activities running against the input which you had. And so, in legal aid, monitoring and evaluation is important to all the stakeholders. So I should not be saying that because I have the money, I can spend it anyhow, because it is available and is supported by a donor. And even the client that is supposed to be served should have an opportunity to evaluate, because that is the only way you can recognize or notice the impact of the legal aid services that you're offering. And of course, to the donor, it is important process, because it will indicate to the donor whether the resources that they have given you based on your inputs and then your outcomes measure up, And that you can only get by your results, and then by getting the people who are being served to verify or confirm that the actual activities that were planned were implemented, and people who are supposed to benefit from that implementation can give feedback, both to you who is implementing, and then in turn, you give back the information to the donor, so they can then use it again for planning for the next phase of the activity. And even for government, we know that services are now being bestowed on government to undertake, whether they have money or not. So when we do M&E for legal aid services provision in the country, it will also help our government in terms of making decisions on what steps, what worked well with the service providers, how the funders evaluated, and see how the project can move forward to the next level. Or if there are things that need to be changed to enable the activities as planned be realized for the benefit of the people who are targeted for the project. When you want to plan for an M&E, there are certain things that you must look at. First of all, you'll be asking the question, who are the users of the monitoring and evaluation framework? What are the goals and the objectives of the program? Of course, these are already alluded to, because you cannot have a project before planning what you want to do, how you want to do it, and for what purpose. There are many ways we can do M&E, and I think I can skip those ones because you're familiar with them, because of time. And I want us to look at Section 7 of the Legal Aid Act. It imposes a duty on the National Legal Aid Service to undertake monitoring and evaluation of all legal aid service providers in the country. However, the regulation that has been placed, you heard it has been put, it is in place, but it has not been gazetted. And it was only launched, I think sometimes July this year. So it is not yet in use. And even if you have to use a framework that National Legal Aid Service is coming up with in their regulations, and more of the regulations, more of code of conduct of the legal aid service providers. And you realize this regulation and the code of conduct are coming when the legal aid providers have been in existence long way over decades, over 2 decades. So also the question I want to ask is, are they properly integrated in the system to allow National Legal Aid Service to undertake monitoring evaluation of these legal aid service providers? Because as a university, we just started legal aid service last year. Okay, FIDA Kenya has been providing for many years. Kellyn, Crew, Koval, so many of them. They've already assessed M&E within their systems. And here, you're bringing for all the service providers. How then can we harmonize to ensure that all these legal aid service providers are accommodated within the M&E system that is being developed now by National Legal Aid Service, because it is a duty imposed on them by the law, without discrimination or without victimizing people who are already providing the services. And of course, that regulation has got so many loopholes, which are, Prof, I hope I'm good on time. The legal aid, the National Legal Aid Service, as it is, if Laura was here, I should confirm to you, they have challenges in terms of staffing, and they have not been, they're not accessible to everyone in the country. And because they are spread thin, I am wondering, even if they have to undertake this M&E, how effective can it be? And can we really leave the M&E function for National Legal Aid Service when they were not there at the beginning of planning phase for these other legal aid service providers? How do we harmonize, the framework to ensure that even as I have developed my own for Egerton University, because at the end of the day, I have to tell Mr. Wambua, these are the planned activities for the year. Activity 1, this is how I've implemented it. And he will ask, but can we do some survey from those people the beneficiaries, to enable us get feedback to verify whether their planned activity as put in the program that you submitted to us has been successful. Because I can create my own successes, because no one can speak anything negative about them. So that's why you need the third eye to ensure that the information that you're giving as feedback is corroborated in the field by a third party when they visit. And that is why M&A is important. And can go on and on. I can only say, as I leave here as a parting shot, that M&A is an important tool for all organizations providing legal aid services. and I'll go back to what I told you the first day. Because we are paid very little money to attend to the indigent, we don't prioritize. I will not go to court because I told you Professor Mbote may have paid me 100 million. So if her case comes and that of the indigent comes the same day, I will not attend that one for the indigent. I will attend Professor Mbote's case. Why? Because it is giving me more money and is going to uplift me more than the one for the indigent. And that's why we're saying when you're developing the M&E, please let us ensure that there is quality in the provision of the work, regardless of the amount being paid. So if we don't monitor, because when you're giving me a free service, it doesn't mean that I should be paying more attention or even the duty of care is less merely because you're paying me less. The ultimate thing is service and the success and the impact that you want to create in that service provision. So the legal aid providers here from Kellen, crew is not represented. I urge you to take M&E seriously. Ensure that your standards of care, your standards of service delivery is at par with the regular services you'd provide to any service that I would render, like for Professor Mbote for 100 million. Because at the end of the day, you want justice. If the service is poor, the standard is poor, then the access to justice is compromised. Thank you.
Thank you very much. I think what question is being asked is the so what? After you've offered legal aid, what are the outcomes? So we need to keep that question. We are going to proceed to the next presentation by Anastasia Otieno. Dr. Aura has kept time, so Anastasia, there is a little pressure.
I hope to keep time. Good morning, ladies and gentlemen. Now, most of the stuff I'm going to say has probably been spoken, but I try to bring a different angle, which so far I've not heard. But that does not mean that my presentation, my paper was limited to only what I have here, because I'm trying not to repeat what other people have said. My paper is on human rights and gender perspectives on legal aid, barriers to access in Kenya. I will not belabor you with the law per se, but I'll only go to the issues of the gender as it relates to legal aid. Now, gender role and experiences determine our access to resources, and this includes access to legal aid, and therefore it affects our rights, our human rights. Now, the next thing that I want to talk about, I'm trying to jump part of my access to an advocate is part of what is envisaged under Article 50 as part of the access, an advocate of a person's own choice, as part of the access to legal aid. And this, it also leads to equality. It also talks about equality to both men and women. Under the ICCPR, there's also the access to an advocate of a person's own, a legal representative of a person's own choice. How does this relate to legal aid? When we come to the Legal Aid Act, you'll find that for a legal aid provider has to be accredited. So this therefore means that when a person seeks legal aid, already their rights are curtailed. The legal aid service provider is the one who decides who is going to, which advocate from a pool of advocates. So you cannot go there and choose your advocate and say that this is the person who I want to represent me. You have to go with the pool, with the people who are already chosen, and thus it curtails your right to legal representation. And this, I'll cite for you case laws which brought out this to the fore. The case of Sheila Amalemba versus Attorney General and others, this was the the Legal Aid Act, stated that the right to fair hearing cannot be curtailed and cannot be achieved without legal representation of a competent advocate of a person's choice. But we can already see that that is being curtailed through the Legal Aid Act. Then in Carissa Chengo and two others versus Republic, the Court of Appeal held that legal representation is essential for fair trial. Legal representation should be provided. That one I think has been said, I won't belabor that. Then in the case of Joseph Mulwa Kioko versus Republic, Justice Kimei stated that the right to legal representation is a component of right to legal trial and accrues to a person who is likely to suffer substantial injustice. So those are some of the barriers already created. And now I'll look at the barriers to access to legal justice. And most of them had been talked about. There's the issue of physical barriers. This is distances from offices where a person would want to access the legal aid. Access to persons with disability, I'm sure, has been spoken about here. Lack of extension workers. Then economic barriers. These ones have been spoken on, so I won't belabor that. Social and cultural barriers. These social and cultural barriers are very important because the kind of issues that people seek aid on. For instance, where there's a commercial sex worker, a male commercial sex worker or a female commercial sex worker, that will definitely have a barrier, will create a barrier to his access to justice through even legal aid. And these barriers are not just, these barriers are caused by our gendered experiences because gendered experiences are created right from birth. So you already have a bias against probably commercial sex workers. So when a person of this kind of person comes to your office, there's already that block. And this is seen among lawyers and service providers, and it's also strangely enough reflected in the court's judgments. If you look at certain court judgments, you'll see that there's a likelihood that the gender experiences are actually reflecting the judgments that come out of our courts. So it's a very serious issue. Then the other barrier that especially women grapple with is the plural nature of our communities. Women negotiate around relationships with men relatives, e.g. husbands, fathers, brothers, in order to access normal rights. So in as much as you would want to seek legal aid, but you have to negotiate, is this going to embarrass my brother? Is this going to brush his ego? So those kinds of things. And this of course hinders our access, the access to justice. And this is not just for the women, it's also for the men on the marginalized male. Because if you're a marginalized person, then you have to negotiate around maybe your more wealthy relatives on whether or not you'll seek legal aid. Then, now, if I have more time, I'll probably just mention that some of these barriers are not easily overcome. And then gendered interventions are really necessary. We need to look at these interventions. Are they really meaningful? And also meaningful, effective interventions, which have been spoken about here. I really don't want to belabor that. And already the Legal Aid Act provides for opportunities to tackle some of these issues. And the Legal Aid Act provides for creation of awareness, research, education, and funding for advisory centers. And it also provides for payment for legal accredited legal providers. But the other thing that I wanted to speak of, and maybe the last word that I say about this, is that the issue of there's also a provision in one of the documents that I read. I think it's the one I didn't mention it. Principles and guidelines for rights to fair trial and legal assistance in Africa. Talks about the need for one to have a lawyer who has the knowledge and skills. As Dr. Aura just mentioned, the most likely person to do legal aid would be a young lawyer who has been sent to go and hold on to that case as the lawyer with experience has gone to attend to the 10 million case. But the legal aid, there's a need for us to provide meaningful legal aid. And usually, there is quite a lot of follow-up. I've been visiting prisons with the students, and you always find that the people in the prisons complain that I haven't even seen my lawyer. He's paid by the government. I haven't seen him. And we don't get to interact. So let's do this work meaningfully when it's given to you. Thank you. I hope I've kept time.
Yes, you have. Thank you very much. I think we've now gotten other perspectives on human rights and gender, but making legal aid provision meaningful. I think that is very critical, that when we do it, let us do it with all our heart, and it resonates with what Dr. Aura talked about. She talked about me giving her millions of brief. And let me just make it clear, gold and silver have I none, but intellect I have aplenty. So we'll have the third presentation from Kennedy Hakaba Omukunda.
Okay, I will ensure I keep the 7 minutes. Yeah, it's fine. Or if it's not, it's fine. Don't delay, but just see. Now, they said that if you're in a battery of lawyers, be careful when you're quoting the acts and the law. They may say, read this one and that one together, so it becomes a problem. Now, my paper is the role of alternative justice system as a complementary pathway for enhancing access to justice. And we are making some radical call up there of a case of intergovernmental relation in access to unit forum. Those who have lived enough will notice that sometimes back, the DO was as good as a magistrate somewhere, and cases were decided as they came in, and there were clear pathway of reporting. So along the way, Kenya passed a constitution in 2010. So this paper is anchored on how do we bring in the county government, as Mutuku was trying to argue out, so that they can also participate in the process of access to justice. So I will introduce by saying that access to justice is fundamental to a fair and inclusive society, and central element in addressing the disadvantaged and inequality. I said I will not quote a lot of articles, but allow me to say Article 6 recognizes both national and county government. And they say they must work together and in consultation and cooperation. And I will add a sentence there that you may realize some functions have been fully devolved or unbundled. Now, the reorganized provincial administration, including the chiefs, the assistant, and the village elders, actually they still provide this service to the community. Now, in my paper, a paralegal is a community person who has been trained for 2 weeks on an approved curriculum to offer services to the community. I'm a bit lower, not up here. I will say this, that the County Government Act establishes offices of the ward administrator, village administrators, and the village council. The question I'm trying to pose is, these are the people who report directly to the county government. So where are their space in supporting the provincial, the reorganized, I didn't want to use defunct because it's still there, the reorganized provincial administration in ensuring that justice is achieved. So this paper is 14 pages. This is how we organized it. I will not go into many stories because many things have been said. We looked at the current system on access to justice since the devolution was put in place. We looked at the previous regime. Then we looked at the international legal framework, looked at the national one, and then allow me to go directly to what I say, the radical call. Now, this is what we are trying to question or ask. The national government is on this side, consisting of the chief, the sub-chief, the village elders, and the Nyumba Kumi. These people, they have clear pathway of reporting. They will not report to the ward administrator. These people come from the community where issues are coming from. On this side, we have a county government, we have ward administrator, we have village administrator. Actually, while we have Nyumba Kumi, this side we have the village, they're called village administrators. They have a clear pathway of reporting. They are in the community, they know what is happening, they are clearly sure of what the county is implementing and issues arising from them. So those who are in the devolution space, you may remember that the Ministry of Devolution was toiling on development of intergovernmental relations unit regulations. How do you bring national? You remember the Joho and the guy who was, I don't know, I've just forgotten his name. They used to fight a lot. We are all in counties, even if you're in the national government. Marwa. Yes, Marwa. You remember that scenario? They used to fight a lot. But they're all serving people anyway. So we are proposing that along the way, can we have an intergovernmental relation access to justice unit that at a very local level, whereby the village administrator, they can be incorporated in what chief is doing along that line. Then we are saying that this is the reason. The functions that are devolved, they are better talked about with the people working on the implementation of those projects. A ward administrator, like say an ECD, education, which is devolved, a chief will struggle maybe to give information, but suppose a ward administrator is there, providing that information and being able to give real-time information. Now we are saying that this unit should be modeled around those who, I know Professor Obire was here with children issues. I've had an opportunity to work with the children for a long time in Bondo and Siaya, and you know, there's a committee called Area Advisory Council. Area Advisory Council deals with the issues of children. They have regulations and they have their composition. And we are also saying that there's a labor committee at the village level, local labor committee. It's knowledge in the space that clearly articulate issues of children who are in the worst forms of child labor. So we are saying in access to justice, let's have the intergovernmental relation unit at the community level, and many programming makes a mistake. The issue is that they train the paralegal at the community level. The paralegal reports to them. We are saying that train the intergovernmental relation unit's composition. Train the village administrator, train the chief, train the local administrators at that level, then allow them to go and train the nyumba kumis and make access to justice as one of the reporting elements every time they report to the upper side. Let the information be sieved and see up here where can it be channeled to. Well, I'm almost done, Professor. The expected role of this unit, we have some, will be to mobilize resources and support access to justice at the grassroots level. I've said CBOs and NGOs train paralegals, but they report to them. So when the program ends, you hear somebody say, I was a paralegal of a CBO X, which it should be to government. Government has many solutions. 2, it will be to recruit, of course, with the support of the available program, facilitate and train the paralegal. And 3, to create strategic partnership. And of course, make decisions of those decisions that can be made at that ground. Sometimes the issue is having a case come from a household to somebody who can help at the community level. The challenges. Of course, we need the procedures and processes and policies and acts. Some people, we don't have that provision. But if it can help, I'm sure a solution can be found. There's need to have either a threshold on what can they handle at that level. And I will say that I was part of the team that was developing regional economic blocks. Of course, I finished. And when we started the policy, they said there's nowhere that regional blocks have been named in the Constitution. In fact, they say, please put off those things. I'm telling you, there's a draft policy that may even be approved tomorrow. So every time that there's a solution to a big problem in the community, the law will get its space somewhere. Maybe BBI 2 will entrench this process. Thank you.
Thank you very much, Kennedy. I think you are getting us to think about synchronizing. When you have so many actors at different levels who are not talking to each other, and all of them trying to resolve issues. And you raise an important point. A lot of the issues we are talking about here, whether you're talking about the rights of children or even gender issues, how do you move them from the household to the public realm? Because you see, the barriers may be more systemic. Like, I think it is in northern Kenya, where women are not allowed to go and put their complaints. So if a woman is battered, who will she get to by her husband? How do you get that problem there? And if she gets another man to go and report, now that begins another quarrel. Who is he to you? Anyway, let's go to the next presentation by Alvin Kosgei. Is Alvin here? Is Alvin here, Dr. Aura? Kome, wasn't he your classmate? He was your classmate, isn't it? Yes, he's not here. I thought I didn't see him, but people change. So we'll go to the next one, which is Anne-Mary Opola. Free, not cheap. Is Anne-Mary here? So we go to Commissioner Muma, and as she prepares to go there, I said, gold and silver have I none. And you know, I know that people think professors are poor. I am not a poor professor. So just in case the young people here say she has validated the poor professors, I have enough gold and silver to feed my small appetite and to buy the small clothes I need. Go on, Commissioner.
Thank you, Prof. Our paper is about traditional justice systems, and it's presented, I'm presenting on behalf of Kellen, myself, Alan Achesa Maleche, Jessica Achieng Olwoch, and myself. Alan Achesa is the ED for Kellen. Jessica Achieng is the program officer that works on this. And Catherine Muma is a board member of Kellen, but also the person who initiated this program while I was commissioner at the Kenya National Commission on Human Rights. This paper is simply telling a story of how we have worked with the Luo Council of Elders to restore property rights for widows who are disinherited. Now, Kellen works on HIV and health rights. So the interest group that we were working with, widows who are affected in the context of HIV. And we found that beyond the socio-economic livelihood needs of women living with HIV, access to justice is a big problem with them. As those of you who know about HIV, women are the most affected. And because of the stigma that has been associated with HIV for a long time, there have been violations of rights in all sectors, as was presented in our earlier paper on the day before yesterday. And of course, women suffer more as a result of this. And most of those affected are not in a position to access justice through the courts, which is the one, the justice mechanism that our government or our nation has elected to invest in. So the project following the experience of Kellen on this project, we lobbied for the inclusion of health status as a prohibited basis for discrimination in Article 27 of the Constitution. We also lobbied for the inclusion of traditional mechanisms in Article 159. And therefore, all we are doing is sharing our experiences and why we think traditional mechanisms are key issues. This conference is about legal aid, and thankfully, the definition of legal aid in the Legal Aid Act includes the providing empowerment on legal issues, on the law and legal issues. It also provides representing in alternative justice mechanisms, but that's just about what it does and nothing more, for at least for traditional justice systems. Now, in this presentation, I will give you the story on how this project was conceived. This is important because anybody thinking of replicating this might want to take into account a number of things that they need to do. One, this project was conceived in 2004. At that time, I was a commissioner at the Kenya National Commission on Human Rights. And being one of the people who worked on HIV and health rights, I was often invited to provide awareness on health and HIV-related rights to different groups. So I had been invited to give awareness to widow support groups in Kisumu County, now Kisumu County in Ahero. And in that meeting, a number of cases were, there were many widows who presented their cases. Many of them had been sent away for one reason or other. Most of them, having had the awareness on HIV and how to ensure prevention of the spread of HIV, refused to be sexually inherited after their husbands died. And they were told that if they refused to be sexually inherited, then they were not going to live in those homes. Many were isolated. The belief was that if you're not sexually inherited, you're going to bring chira. And Prof. Lumumba can tell you what chira is a little later. And therefore, to avoid you bringing chira, they would isolate you. Your children cannot play with the children of other people. You cannot start tilling the land. So the growing of you can't plant in your land. And in the end, even your own nyekas, who are your co-wives, wives of your, wives of brothers and cousins of your late husband, would join in the pressure, in trying to bring pressure upon you to get you to be sexually inherited in order for the village to start planting. So there was a lot of pressure on these women, a lot of them young, and others were accused of killing their husbands with HIV. Others were suspected that they'll probably go off with, because they are young, with other men. So there was all manner of abuse and violence against these women to the extent that it became unbearable for most of them to live at home. So most of them took off. A few of them actually were violated to the extent where one of them I remember told us she had gone to till her land. She decided she doesn't care, she's a Christian, she's going to till. And she just saw her house on fire. And she actually just left with her child, nothing else. They ended up, most of them ended up at the market places. They would rent houses. Some of them engaged in sex work. Some of them, their children engaged in sex work, and the stories were quite a number. So now, we then asked, did you go to the chief to help you? And I'm mentioning this because of Kennedy and Tim, who are thinking of that mechanism. It turned out the chiefs would just tell them, why don't you just accept? This is the culture. So just to tell you that the provincial administration has no authority over culture. So they also are helpless. They're not able to step in and help these widows. So the widows just took off and found themselves living at the backs of the shops. And they formed widow support groups. And I think they were psychologically supporting each other in that regard. So after hearing these cases, I came back to Nairobi and I was disturbed. When you go on with your human rights quoting CEDAW and everything else, and you realize that CEDAW means nothing to that widow, it really disturbed me. And I spoke with my colleagues in the Kenya National Commission on Human Rights. And the first reaction from my colleagues, especially the female, was that I suggested, why don't we try and work with the elders to see whether they can help these widows. I was told, how dare you even think that? It is the culture that is being used to violate these women. How can you even think of working with cultural structures? So I went to my chairman, Maina Kiai, and spoke with him, and he told me, I think you have a point. I've worked in Nigeria before with and I'm aware of some programs where elders actually resolve disputes. And I think, let's try this. Now, I was very well aware that I'm attempting to create a solution to a cultural problem, but I'm not a Luo. I don't come from that community. So properly speaking, I have no authority to even start doing what I'm doing. So we thought through it and decided the first thing we will do is try and work, mobilize the leaders within the Luo community to own the problem first and help us to create the solution to that problem. So the first thing we did is organized for meeting between Luo women leaders and the widow support groups. So we organized meetings in Homa Bay and Kisumu and brought down Phoebe CEO, Asana Thodaga. If those of you know, the late Asana Thodaga has written quite a lot on Luo culture. I remember Professor Penina Ogada, Dorothy Nyong'o, a number of women. We brought them down and actually sent them to different widow groups because we learned that this is not just the women I was meeting. It is happening everywhere. So the women went into, it was a 2-day meeting. The first day, you go and sit and listen to the widows as they tell their stories. And what happened is that in every one of those stories, all these women were breaking down as they had the ordeals that the widows have gone through. Day 2, we then met now with the leaders of those support groups and for the women to give us feedback. And they were angry enough, adequately angry, to decide that this is not our community, this is not our culture. Many of them knew what the culture is. Asana Thodaga told us this is nonsense. Phoebe CEO told us this is nonsense, this is distortion, these are just young men who want to take the land of, and so on. And that was music to my ear. I thought now I'm getting the reason to convene this. We then decided the true owners of culture are the Luo men and the leaders. So we decided the next thing we will do now, we are planning with the women leaders to prepare the widows to present their cases before the male leadership of the Luo community. So we organized a big community meeting in Kisumu Sunset. At that meeting, we invited all the opinion leaders, most of the opinion leaders from the Luo culture. The CARE and the entire team, Luo Council, and the Luo Council of Elders draws from all areas. We invited Professor Bethuel Ogot, a historian who's written on the Luo. We invited the late Professor Okoth Ogendo, the leading lawyer then on Matters Land and others. We invited Professor Ogutu, who used to speak a lot on culture. Professor Ndinya Achola. At Lumumba, you were there. You attended that meeting. We invited Professor Nyang' Nyong'o, we invited Raila Odinga, then the Minister for Works. And the first session was to discuss Luo culture on inheritance. And we were given this beautiful culture about how Luos took care of their widows, widows are valued, all of this, and I loved that because I was like, now I have evidence to go with this. We then discussed widow inheritance. And we were told what widow inheritance was all about. It was a social support system that ensured that there was a father figure within the lives of the children of the orphans that have been left. The inheritor would be a younger person, and it made sense that when a widow is left, they also have sexual needs. So they are kept within the home. A younger brother would come and inherit them, and they would get children. Those children that they would get are children of the dead. They belong to the man. Then we discussed sexual inheritance in the context of HIV. And it was agreed that there are other alternative ways of retaining the social value of widow inheritance without using the sexual act. And I remember Okoth Ogendo telling us, in fact, the mother was inherited while she was older, and all that the person did was to remove one iron sheet from the roof and to replace it with another, and that was done. And somebody else said the man, whoever is supposed to take care, might give you his coat, you wear it, and that is done. So they were able to provide symbolic ways of widow inheritance that do not involve the sexual act. Now, once that happened, next session, we told the widows to tell their cases. And the widows told their cases. And the Luo Council of Elders were outraged. In fact, they said, we have actually coached widows to come and spoil the name of the Luo community. So they were so enraged and decided they are going to investigate those cases to see what is happening, because we can't be telling the truth. And I loved that. So thereafter, they then decided, where do you come from, Nyakach? They go to elders from Nyakach to go and investigate. And in all of those cases, they found what the widows were saying was true. And they reinstated them. Moving forward, we then started working with the Luo Council of Elders to get widows reinstated. And as we are speaking today, okay, once I left Kenya National Commission on Human Rights, many people did not find that project sexy. I continued it in Kelin. That's how it moved into Kelin. Fast forward, we now have reinstated more than 700 widows. I want to try and meet those minutes. I'll move to the challenges. That one, we have reinstated all of those widows. But as we moved forward, there are a few challenges which we need to take into account for anybody trying to repeat this. One, we found that many of the widows, because they were very poor, were not able to take possession of their land. You've been at the shops, you've been told now you can go home. But you're so poor, you're living from hand to mouth. And we felt very deflated that we managed to get this lady to access her right to property, but she can't occupy that land. So we had to come up with a second proposal to build houses for widows. And there are not many donors who are willing to do this. In fact, we've done a number of building of houses for widows, but the donors have since stopped that. We continue, we do once in a while after fundraising from amongst well-wishers. But we did that because we felt if she can't occupy that land, then that right is not properly secured. So that's one of the things you find if you're working with the very poor. And then, number two, much as the elders reinstate them, the lady, they don't necessarily get the title, because the title is a family title. So the question would be, how do we ensure that when they eventually do a subdivision of that land, if they do, that the widow will get her title? That's another headache somebody has to think through. I think we've helped one or two, but the rest, the title is still in the family name, and we don't know yet how that happens. And then, the Luo Council of Elders at that time existed as a political entity. There were not a dispute resolution mechanism. So what did we do? We actually reconstructed. They used, in terms of the old custom, they used to resolve disputes. But at the time we were doing this project, they did not exist as a dispute resolution mechanism. It was formed for purposes of this. So if you're going to another community, you may have to reconstruct that mechanism in order for it to do what you want them to do. And then the project has largely been supported by development partners, not by the Kenyan taxpayer. So again, we need to think through that. And then the project only focused on property rights. It did not resolve other violations against the widow. The widow whose house was burnt, for instance, that was a violation. Some of them were actually forcefully raped, I would put it that way. Somehow they just moved on, and nothing was done about that. So there are other violations around the widows and the orphans, which our model did not, because we were just focusing on the right to property. Finalizing, Prof. And then when it comes to it was a good thing that elders are not remunerated. So if you go to a community where the elders will be expecting to be remunerated, again, that will be a challenge. And then in terms of policy, much as the Constitution provides some wording that should form the basis for a policy, we don't yet have a policy. The Legal Aid Act 2016, despite coming in force after the Constitution was put in place, has completely avoided reference to traditional dispute resolution. It talks about alternative dispute resolution, and that meaning does not take the wording of Article 159. And because it doesn't, therefore it doesn't provide for it. And we feel that needs to be sorted. And then the AJS report is underwhelming as far as I'm concerned insofar as matters traditional justice system are concerned. It has actually reduced all alternatives into one phrase, alternative justice system, and proceeded to give recommendations on that as if it is one system, and yet it is different systems, with one of them being totally different. So my recommendation is this, that there is need to get maybe the universities to help us to partner with CSOs and to help to unravel ways in which the traditional justice mechanism can be operationalized, and to help us also document key cultural practices that we should negotiate negative issues out of and reinforce the positive issues. So I'll end there, and thank you.
Thank you, Commissioner. You have managed to take more than 3 times your time. And the only reason that I let her go on was the point I made about decolonizing, because she was talking about traditional justice systems. And what I also picked is that professors are also carriers of traditional justice, because Professor Lumumba was among the elders that were being talked to. But I think there is another point that comes up from this traditional justice, the whole question of, and especially where you're talking about property rights, the whole question of legality, that you can have a legal right to occupy, but you don't have legitimacy. And I think that is the social engineering of working within the community to make it accepted that widows can actually live there. Because we do know the law of succession allows married daughters to inherit land from their natal homes. But that legal right is nugatory if the people who you're going to live amongst do not consider it legitimate. So those are the issues that we deal with when we're talking about traditional justice. Now I'd like to call on Shem to make his presentation on the efficacy of alternative justice systems in rural areas. And I think that follows on what we've been talking about. Please put down the questions that you have for these presenters. We are going to have a point at which you can ask those questions. Shem, you have the floor. And you will not be treated as well as the commissioner, not because you're not commissioner.
Last time you say, when she sat down, you said that it's because she was speaking on this topic, which I'm also going to.
So let us hear you. Let us hear you.
All right. Thank you. So as you have heard, my name is Shem Uganga. Before I begin, allow me to invoke the words of the Holy Book in chapter 5 of Amos. The prophet writes, but let justice roll on like a river, righteousness like a never-failing stream. So I stand here to speak for those who cannot speak for themselves because they've never seen that river. The rural resident swims in a different river, the alternative river, as we've put it. So my presentation today answers 5 questions. You know when someone is only answering questions so that you will just listen. It's only 5 questions. Now, which is the alternative? You know, the word alternative means that alternative is a word that will just mean something that is rarely used, all right? So if 95% of the population uses the alternative justice system that we say because we are lawyers and jurists, then are we not the alternative? So we should think about that. So who are the actors of this system? We all know Article 159. So the actors are the mediators, negotiators, and all those. But most importantly, the elders. And I will not say these people are the part of the informal. Now for me, the informal are the chiefs and the policemen, and I will say the clergy. And then another question I have is, why is it that 95% are going for this system? So I found 2 answers. There are push factors, factors that push them out of the judicial system. So I'll only point out the important ones because we are all lawyers and we've spoken all these issues for long. I'll point those issues that have been rarely spoken about. The economic aspect. So I'll quote Professor Yashpal Ghai in his book, Political Economy of Law. He says that the court system is tailored in a way that, okay, if we imagine the court system as a market, the judges are the sellers, and the customers are the citizens. And then the judges give goods. The goods they give are orders, injunctions, and all those kind of sorts. And then the clients or the customers are the citizens. And now, because it is a market, the most people who come to buy the goods are people from the cities and the towns. So the judiciary is tilted or tailored towards serving the needs of the people in the cities and the towns because they are the common customers. And the court does not bother itself to go further and expand its market because I think maybe it is because it is satisfied with the customers or the customer base. And then other issues are the bias, stigma that is towards the poor rural residents. The rural residents are mainly uneducated. They come to the court in dirty clothes. They don't know the language. And because of that reason, the judiciary or the actors in this court system, they look at them in a negative attitude. And at the end, because of this bias, they are always deemed guilty, dishonest, and we look at them as lazy people who are irresponsible. And because of that, they never get justice, so they are pushed out. And another issue is underfunding of the judiciary. You know, we talk this about austerity measures. These austerity measures have a ripple effect to the rural person, because if you underfund the judiciary, the ripple effect is we'll employ austerity measures. We'll say we are not expanding, we are not building more courts, we are not employing more court officials, which means we will only retain our services within the cities and not go out to call upon or serve the rural resident. So, wonderful. And another thing is there are no incentives for the rural person to come to court. For example, our witness protection mechanism is not all right. So someone is taken to court, you are the witness, and then he's brought back out of bail, and then he comes to haunt you in the village. There's no policeman to protect you. So why do you have to go to court well, you know that he will go out of court on bail, and then he'll come for you. Then the pull factors. They are the factors that pull the people into the alternative justice systems. One, the courts are the creation of colonial masters. So we have this factor of cultural and social acceptability and appropriateness. Because the courts are the creation of colonial masters, in the village, we view them, we view people who go to court as people who have betrayed us, all right? They are traitors, and we don't view them so well. And another thing is, if you look at the book of Luke chapter 12, verse 58, these are the words of Jesus. He said, when you have a conflict with your adversary, solve it quickly before he goes to court, because when he goes to court, he will go before the judge, and the judge will hand you to the prison in charge, and then the prison in charge will throw you to prison. So, as the clergy and members of the church, we're always urged that solve your issues out of court. Don't go to court because, or I don't know, those are secular people. So most of the issues are mainly handled outside because of this, and the way the religious leaders encourage us, or they impose these words of Jesus that don't settle your matters to court, it's better you do it outside. But most importantly is the restorative aspect of the alternative justice system. Whenever you have a case, it is solved outside before the elders or the clergy. You are compensated. There are goats or any other form that you are compensated. And then the person who messed you up is either banished or rebuked, which rarely happens in the formal court system. Now, in a nutshell, I will go to the question 5, so which means that I'm winding up. Now, how do we enhance the alternative justice systems? My first point is that we should involve lawyers. And as I stand here, I believe I am an interventionist, and I believe law is a tool of social engineering. So we should involve lawyers. So alternative justice system is not a hostile takeover, but instead it is a system that has been propelled even through the Constitution to help in the delivery of justice. So there are ways that we should involve lawyers. One is through legal literacy, to teach special groups about their rights. For example, women, about their right to property and to inherit, and the children, their rights, and those people with special needs, the blind, the deaf, all this. It's only through legal literacy that we can bring them up. And another thing is the main reason why we should promote legal aid in alternative justice systems is because we want to promote constitutionality. We all know Article 159 and Article 10, those are our values. And so we want to uphold the rule of law, natural justice, and public policy. And this can only be done if we involve lawyers in social engineering, like the good commissioner has just said. For example, this issue of inheritance of widows. And we have female genital mutilation. How do we deal with this? We can only deal with this if we involve the lawyers in social engineering. Our culture is not perfect. We don't want to colonize our culture, or are we imposing any values, but we are trying to remove the bad and remain with the good, which there are, right? And another thing, the Council of Legal Education to form an alternative justice system curriculum, which paralegals and lawyers will be trained on. So this curriculum should remove the technicalities and the legal mambo-jumbo that we have as lawyers, but instead should only have that law or language that tries to educate people about their rights and promotion of constitutionality and the rule of law and natural justice. And another thing is we need to recognize the role of post-colonial actors. So these people who came after the colonial system, like the chiefs We need to look at the clergy. One, we need to accredit the clergy. It is my view that we need to, for example, the clergy can be an important tool in mediation, negotiation, and conciliation. And it is important that we teach them on the values and principles of mediation, conciliation, and negotiation, because they play a very important role. And then, if you're a common man, you will understand the importance of having a paralegal in a police station. Because the common man, the most of things he does, when he has a case, he normally goes to the police station. It is his first center of reporting. And so the policemen, you find some of them don't know the law. This matter can be best handled as a civil matter, or this case, you don't have enough evidence. It is best we just bring that person here, we tell him, you've messed this guy up, let's clear this issue, instead of going to court, or kind of that stuff. So it is very important to have a paralegal in a police station. Every police station should have a paralegal. Now, another thing is we should pay the actors. We should pay the nyumba kumi and the elders. Because if you don't pay these actors, then they will use favors that they get, and then at the end, when we expect justice through the alternative justice system, we'll just find it is a monopoly. And then another thing is we should provide a policy to guide when conflicting customary laws collide. For example, remember the Wamboyo Etieno case. How do we go about that? So, you know, I read the baseline, the judicial baseline policy. It does not deal with that. So we need to provide a clear policy. How do we deal with two customary laws which are conflicting? And then as I almost end, I'm going to a very important aspect. The elders. Let me honestly tell you, the council of elders we have, they are not the pure elders that we used to have in the pre-colonial times. The elders we now have, they're elders out of political influence. They are not the perfect elders that we had. So it is very important to come up with a mechanism of how these elders are appointed. We should accredit them and come up with ways for their removal. Not through laws, but through involving them. You know, the former Chief Justice, Dr. Mutunga, was always organizing committee, and I think it was because of that his meetings with the elders, it is because of that the AJS policy baseline was formed by the Honorable Justice Ngugi. So, like for example, we recently had wrangles amongst the Luo Council of Elders. I don't know if you people have heard that. And then we normally have, like, in one community, we have various council of elders. And these council of elders arise almost towards the political seasons, like, 2022. Or we are the Kalenjin Council of Elders, and we are supporting Gideon Moi. And then we are the de facto Council of Elders, we are supporting Deputy President William Ruto. And then we are the Njuri Cheke, we support, who was the former governor of Meru? Munya, we're supporting Munya. And then another will come that we are the Njuri Cheke, we are supporting Kiraitu Murungi. So these Council of Elders, at times, the way they are chosen should be questioned, and there should be clear and known mechanisms on how they come to be. And then as I wind up, we should define the jurisdiction of the alternative justice system. You know, when you read the AJS the baseline policy, it says that we should use the agency theory. And then Ngugi goes ahead and says that this agency theory, it is like we get all the powers through the citizen. And if he does not want his case to be tried in court and tried elsewhere, we should just let him be. And we should not put a demarcation on which case should be handled by the alternative justice system. But for me, I disagree. Because I believe one thing: if we want to uphold the rule of law, natural justice, uniformity in public policy and morality, then we have to put a demarcation. For example, sexual offenses should not be handled by the AJS. Another thing, like the case we have about murder, the murder case that was handled by the elders in Northeastern, by I think the Blue case, 2013, and other cases have preceded that. How is it that the court system allows someone who's been murdered, that the people to agree outside. I think this repudiates the foundation on which the state is based on. The main reason why the state was formed was to protect life, and that is the main reason. And if anyone takes away life, it should not be taken elsewhere. It should be handled by the court system and be charged appropriately. We should not use excuses that maybe witnesses were not there. It is because our witness protection mechanism is not proper, and our investigation are not proper. So we should not abdicate our duties to the alternative justice system and then just say, like, let us just be pedestrians and not interfere. But we should define the jurisdiction. For example, if you look at the laws, this policy is contradictory to the alternative dispute resolution bill that is in Senate. This bill, if you look at section 4, it says that the jurisdiction of the alternative dispute resolution should only be with certain civil cases, and not even election issues. So when we have an AJS baseline policy saying that we should not discriminate on whether it is a criminal offense or a civil issue, and we should not discriminate on whether it is a grievous matter or a little matter, a petty issue, then we should be careful on where we are going. And so, ladies and gentlemen, these are my issues, or the issues that are raised, that if we attend to, then our system, alternative justice system, will be effective, and then it will serve all citizens. But let us not forget that it is serving 95% of all the cases. So we, as the members of the judiciary or lawyers, should rise up and try to do more as we serve justice to the people. Thank you so much.
Thank you very much, Shem. And I can see you are a reader of the good book. And you have taken what Paul says to Timothy: do not let anyone look down upon you. You should be an approved workman who is not ashamed. So you were able to withstand my pressure that you are not keeping time. I think Shem raises a critical issue about, one, the autochthony of the councils of elders that are now coming up. Are they bona fide? Are they really the councils of elders? He also raises the issue of post-colonial structures, and I'd like us to think about whether chiefs and clergy are colonial or post-colonial. Because you see that's an issue. He talked about the common man, and I wondered about the common woman. There is a book that was written by jurists in Southern Africa looking at women's experiences with the legal process. And it's actually titled In the Shadow of the Law, because they really don't appear in the law. So maybe just think about if a man is invisibilized in the legal process, what happens to women, to children, and to others who are not man. And my last point is, I have my favorite article of all times is The Man of Law. And I'd urge you, if you can, read The Man of Law, because when we assume that man is privileged by law, the question is, are all men full men of law? All. And my assertion actually is that we are not all full men of law, because if you are a black man, that melanin in your skin detracts from your enjoyment of your rights. So racism comes in. That's what I'm saying. So in essence, let us always think about what are the experiences of those others, even when we are enjoying our rights. So I'd like us to have the last presentation for this session before we have tea. And please put down your questions. And this is by Samuel Moy. Samuel Moy is presenting on implementing mediation process as an efficient dispute resolution, for efficient dispute resolution in Kenya. Moy, you have the floor.
Okay, thank you. I'll start by referring to some of the presentations that have been done. And one of them was by Professor Wabwile. And he said, there is no reason for a parent to be served with a court order on maintenance of children. Then Morris talked about a situation where a widow has been able to acquire or has been able to get a judgment in favor of in-laws. And he was asking, how are you supposed to approach in-laws when you have won a case against them? Then I want to refer to a statement that was made by Professor Bote, is that 90% of people in Kenya are not enjoying the services of the judiciary, and that has also been stated by Shem, that is the previous presenter. And I want to start with a case scenario. Actually, it's a case where I was involved in mediation. And it's a simple case of women at the village. And there were 6 women